So what does failure to protect mean in a California CPS case? Failure to protect generally should mean, hence should mean, the inability of a parent to essentially supervise properly, inability of a parent to properly care, inability to properly protect the child from any particular reoccurring danger. Now, I mentioned should be because oftentimes the department and social workers will use failure to protect as a general catch-all allegation. This is referring to generally in the B allegation to justify the removal. For example, one incident or isolated incident of a parent failing to supervise that led to something traumatic that can be easily remedied, can that constitute as failure to protect? A person who consumes alcohol or marijuana that doesn't affect their ability to care for the child, and the only reason why the case opened was because another parent made a report that the parent drinks alcohol or smokes marijuana or etc., leading to an investigation. And though nothing has taken place, the children's education, well-being, emotional well-being is well taken care of, and there's no evidence has been affected, yet social workers will use any type of evidence of substances to justify a removal, saying that due to the parent's substance abuse, there was a failure to protect the child from future type of danger. The question is, what danger? Another thing is, what constitutes as abuse versus use? There's a distinction between use and abuse. Domestic violence is an example of that can lead to a failure to protect if the incident has taken place and the child is present. Now, oftentimes, counties will still make a decision to remove, even though there's a clear victim and clear aggressor, and this is an isolated incident. They'll make the decision to remove from both parents, which generally should not be the case because the goal is to make reasonable efforts to prevent removal. And one of the ways that can happen is filing restraining order against the aggressive party and having a safety plan in place to protect the child from any future DV or domestic violence. Unfortunately, that's not the case, and the default is to failure to protect. There are so many ways that can mitigate the damage and ways that can prevent from a case being failure to protect. But generally speaking, failure to protect is essentially when a child has been injured in the parent's care due to failure to supervise, due to properly care, or inability to be present due to any particular type of substance that has taken place. If you are in a category of failure to protect, make sure you contact California CPS defense lawyer to see if it's actually a true failure to protect versus just a general catch-all phrase. You want to make sure you litigate it and you fight it and not just let it go. At Shatu Law Firm, we're here to help.